All right, we are a little bit past time here. We'll go ahead and get started with the Public Safety and Homeland Security Committee meeting. I'm going to ask Representative Danny Mathis if he'll open us up in a word of prayer.
Thank you, Chairman. Father, we just ask you to be with us as we make decisions here today to help keep Georgians safe. We thank you for your son, Jesus. In Christ's name, amen.
Thank you very much. All right, ladies and gentlemen, sorry for the little bit of a delayed start. We, like most folks across the street and over here, we're all trying to find enough people to constitute a committee so we can have a meeting. But we're going to go ahead and start with Representative Jordan Ridley. This is going to be a hearing only on House Bill 930. So, Representative Ridley, if you would like to go ahead, the floor is yours.
Yep, just to make sure, we're on LC 481206S. And this bill, we had a hearing only in subcommittee, and then I worked with Chairman Saines on the language to clarify and make it a little easier to understand and just clean it up. But the intention of this bill is for people's mugshots that they're not released until after conviction. You know, in this country, you're innocent till proven guilty. Mugshots are being weaponized across the country on social media. People are getting bullied over mugshots and then being found not guilty. So people are having issues at their universities, in their jobs, their careers, and then they get found not guilty. Well, it's not fair to them that their mugshots have been used when they're supposed to be innocent until proven guilty. In other countries, like in Britain, you're guilty until proven innocent, but our founding fathers made sure we did the opposite, and mugshots, they're everywhere now. There's magazines selling, you go in the gas station, you can see them in magazines all over social media. And the language we worked on in subcommittee with Chairman Saines on was over here on lines 21, 22, and 23 about when the exemption, when they can be released. And it's until the individual has been convicted, the photograph wouldn't be released, except there is an exception as determined by the written declaration of the sheriff of the applicable of the county if there is a public safety reason. So if there is some reason, like somebody doesn't show up to court and they've been charged with murder or rape or something that is of public concern, the sheriff can get that out there, let people see it, and make sure we get those public safety issues handled.
All right, thank you. Any questions from the committee? All right, Representative Cummings.
Thank you, Chair. I want to thank you for this bill. I think it's much needed. And just for clarification, this would stop like the media and newspapers from flashing you the day of or the next day with your mugshot photo. That
Correct.
Would stop that?
Yes,
all
ma'am.
of that? Okay. Thank you.
All right. Anybody else? Any other questions? I know I'd heard this, I believe, in judiciary non-civil in another form. That
There is another version run by some other, but theirs is different.
Yeah, and so, but there's been some changes to your version since we've last heard it, and I think that language you and Representative Saines worked on limits the release of that, because I think at one time you talked about being able to release it if it was a law enforcement agency in general, but now you're saying if it's for a law enforcement purposes, like notifying the public if there's somebody on the loose or something like that. But
We
otherwise,
cleared it up to make it easier to understand of when it can and can't be released, and we struck out basically a page of the exemptions at the end, and then just changed in the beginning in those first lines that not at all except by a written statement by the sheriff for a public safety concern.
and I know that you've always been able to. So in my local newspaper in my hometown, they have the docket they print every week of those people who have been arrested, what they were charged with, and that sort of thing. This doesn't limit that.
So
correct?
There's no exemption. So they will not be released until you're convicted unless the sheriff.
Well, but that was just their name and the charge.
Oh, if it's just the name and the charge, no, it's
so
the
this only
mugshot.
applies to the mugshots,
Correct.
not their name being released on a court docket or anything like that. That's still
sorry for the
public
misunderstanding.
information.
Yeah.
So, okay. I know we had a sign-up sheet, but I know Terry, you were outside. Did you want to speak to this real quick? Okay. All right. Go ahead. Yes, sir.
Thank you. Mr. Chairman, I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association, and the mugshot issue is a problem. It was worked on over 10 years ago in the House by then State Representative Brian Strickland. It has become a huge burden for sheriffs to reply and respond and comply with the open records request on mugshots. Presently, sheriff's offices can post mugshots on their website. Most do not, for a variety of reasons. So most sheriffs will require the media or whomever else to submit an open records request. Sheriffs can't keep up with open records requests now. You know, we can't hire people to start with. It is a huge complication in the staffing of sheriff's offices to comply with all the open records requests, plus restricted records and other things. So on the matter of mugshots and those mugshots not being released until post-conviction, this is totally unachievable for sheriff's offices to know who's been convicted or not. Most counties do not have an integrated criminal justice history system, so that everybody knows instantly when someone is convicted. So if this bill were to pass, and Representative Bruce has a similar bill, which we understand as well, if these bills are to pass, sheriff's offices are going to have to, on every arrest, for every day until there's a conviction, try to find out through the courts if there is a conviction. So this is totally unachievable to sheriffs. And I spoke with Representative Ridley before. We want to help, and we want a solution, because it is troublesome in many ways to sheriff's offices. So again, it's not achievable to sheriff's offices.
All right, thank you, sir.
Yes, sir.
Any other questions from the committee? Is there anybody else? Oh, sorry. That would be Representative Evans.
Thank you, Chairman. So what is the representative's response to that?
My response would be, we just talked about outside a moment ago, but my response would be when I was a state employee and we had to respond to open records requests, if you don't have the information, you just don't have it. So if the sheriff's office, and I'd have to check with legislative counsel to find the legality on it, but if the sheriff's office doesn't know if they've been convicted or not, I think that would be their response on why they can't release it after conviction. Like if they don't know, there's plenty of times open records requests are done and we say we don't have the information or we don't know what you're looking for.
Does the chairman or any other member of the committee have a response to this question?
I don't. 24 is blinking. Maybe Representative Lott has one.
I had a question too.
Oh, okay, go ahead.
Sorry, I have no response to that. But so, and I'm not sure again if you have the answer to this or if it's Mr. Norris. But how is it working now with what is the requirement now of what they expose? And how quickly is it exposed? And why are we just talking about photographs versus the rest of the material? I guess I'm just trying to figure out what the difference is
So
here.
the big difference is, like, with the photographs and now with social media, it's easy to identify somebody, and you have a college student that got in trouble or something like that. A senior in high school that is over 18, their mugshot gets released, their peers see them, they're bullying them. In older circumstances, people have gone through divorces, spouses have filed false charges against them in their divorce proceedings for various reasons. Those mugshots are there, they're sending them to work. If you're Bob Smith, there's 1,000 Bob Smiths in Georgia, but when they have your photo and they send it to your work, then it's like, hey, this guy got arrested, and the connotation of his mugshots, versus the writing on the page.
Thank you.
All right, Representative Evans, you got one more.
Yes, thank you. So I know in this committee we've studied about the different types of systems, of IT systems that keep data, and it seems like this is a hearing only, but maybe I would like to understand why the systems can't talk to each other more. Like if someone's been convicted, there should be some integration so that the sheriff's office would know. I mean, like as a layperson, I would, I assume that kind of communication would exist. And I guess if it doesn't, what do we need to do to fix that?
Well, I think that, and I don't want to speak for all the sheriffs, but, I worked for several different departments, and they all have differing levels of technology and the capabilities and the budgets to instill some of those. Some of them are still paper convictions that come from the court. Some of them take more time, and then they go to a certain part of the department that maybe there's one part that handles what has to be done with a conviction and another part that would handle open records requests. So I think it's trying to keep all of that straight that I think would be an issue they would have to check back and forth on. So Representative Cummings.
Yeah, I was just wondering if there's a request made after the conviction for the mugshot, can something be added that the requester would have to put the date of the conviction along with the court and everything else, and then that would give the police the opportunity to just confirm it before they release it, as opposed to them being obligated to keep track of it?
Yeah, that's there's a lot of thank you for the question. There's a lot of different scenarios, a lot of different things, which is one reason this was just being done as a hearing only first. And I know that Representative Ridley and Mr. Norris and the Sheriff's Association are talking. There's a lot of discussion to be had. It's obviously a problem. Real quick, I did want to ask Jenna. I saw her sneak in over there. Did you happen to have an answer to that previous question that Representative Evans had?
The open records?
Yes.
I'm not super familiar with open records, whether you can just choose to not try and find the answer if you can't find the answer. I guess that I don't know.
Okay. All right. Anybody else have anything? We look forward to continuing this conversation. Oh, our chairman would like to speak.
Yeah, I just want to say to Representative Ridley, I think we need to continue to have this conversation. I feel very strongly about this business model that's been invented and is profiting off of the misfortunes of numerous Georgians who are booked and accused of a crime. But at the same time there, I also want to make sure that we're not going to put an undue burden on our local government partners that need and want to release those mugshots. I think what the Sheriff's Association brought up is a very valid point. And I certainly don't want to do anything to tie hands of law enforcement. And I appreciate your willingness to work through this process. And if we don't get this through this year, there's always next year. But
absolutely, and it's getting the conversation started and getting all the stakeholders here. And I think everyone, after the 2 hearings only, I think everyone kind of agrees the business model of profiting off people's bad days is not acceptable, and we need to figure out a solution.
Absolutely. So thank you.
Thank you.
All right. Thank you, Representative Ridley. All right. Now I'm going to turn this meeting over to Chairman Collins, who is here now, and ask if I can be excused. Thank you.
Thank you. This time of the year is always interesting. We play musical chairs, and sometimes the tables don't turn, but people's seats change. So we'll move right into House Bill 996. Since Representative Vance is not a chairman, but we're going to call him chief. He'll be the chief of the Public Safety and Homeland Security Committee. That'll be an honorary title for him.
I appreciate that. Thank you, Mr. Chairman, committee. I bring to you today House Bill 996. We're operating off of LC 394093. I've been told since I've been here for a couple of years that when you bring a bill, is it good for Georgia? Is it good for Georgia? This bill is good for Georgia, particularly law enforcement in Georgia. The situation we have now is that I'm not talking about the Cobb counties, the DeKalb counties, the Fulton counties, the jails in those areas, because they have this. I'm talking about probably the 135 to 150 counties outside of those that don't have this ability because of manpower and staffing and just oversight of the law now. What this bill does will allow jailers who have been certified by Georgia Peace Officer Standards and Training, they have to go to jail school, as having successfully completed the course, shall be authorized to arrest any person found to be in violation of a criminal law that occurs only within the jail or the perimeter guard lines, not outside of that. Just those things that happen in the confines of the jail perimeter guard lines. And currently, if you have a situation where I go turn myself in to the sheriff's office in Putnam County, Georgia, they have to call a deputy, which they may only have 2 deputies on the road, to come in when that jailer's already there, to come in and take custody of me and turn me over to the jailer who's standing right next to the person. That's a poor use of manpower, in my opinion. This law would really help those sheriff's officers that are understaffed and have always been understaffed in the jail area to handle those kind of things. Now, obviously, if it's something magnanimous or big or something like that, gargantuan, then yes, everybody'd come. But on these circumstances where they discover contraband in a jail cell, they would be able to effectuate that arrest at that time, and then with the help of the investigators and the sheriffs, they could fill out the paperwork and go forward, rather than having to say, stop, time out, let me call a deputy off the road to do those certain kind of things. That's all this bill tries to do, and it really will be a help to law enforcement in Georgia.
Okay. Your explanation has drawn a few questions here, so
Always do.
we'll recognize our friend Representative Evans at this time.
Thank you, Mr. Chairman. Thank you, Visville. So the people that the jailers will be arresting, are they people visiting other people in jail? Is that, or, because I mean, like, if the person's in jail, why do they need to be rearrested? I'm
Recharged.
Recharged.
Yes, ma'am. My wrong use of the word, but recharged. If I go into your cell and you have contraband in your cell, I can make that arrest then. You're still going to be in jail. I'm just going to add it to 2 things without having to call a deputy in to take that report, to do all this and move forward.
So it's just adding an additional charge
Correct.
to whatever they are already in
Correct.
jail for?
That's correct.
Okay, thank you.
Right, now just to make that perfectly clear, just because you're in jail doesn't mean you can get away with criminal activity.
That's correct.
You can be charged with new offenses.
Correct.
If you have.
And that person right there who witnessed the crime can make that charge. Plus, if an officer, a jailer, is accosted in that jail, same kind of scenario, same kind of thing. They don't have to say time out. Once we get through fighting and cleaning up, we'll call a deputy in to take the report. It's just way more efficient this way.
We'll now recognize the distinguished gentlelady wearing the winter white, Representative Lott.
Just to be clear on that, I think it may be written this way, but it is any person within the jail, though, if by maybe what she brought up, it was a visitor, it would as well
Yes.
be included.
Yes.
And can you just clarify one thing for me on coming into the last 2 lines? Jailers shall be further authorized to exercise arrest powers upon any person for whom a complaint or arrest warrant is pending who surrenders into custody.
If I come to the jail to turn myself in,
Okay.
I don't have
That
to
makes
call
sense.
a deputy off the road. That jailer can take me into custody and process me into the jail.
Excellent. Okay, I understand. Thank you.
But I'll make that one more statement very clear. They have to have been through jailer school, and they have to have
Absolutely.
a post certification.
Yes, they have to be.
Just not someone who
No.
is working at the jail.
No, they have to be a certified jailer under the Post Act.
Representative Cummings.
Quick question. I just wanted some clarification, like, from working in the federal system, if somebody committed a crime and they went to detention, we had a department that merely sent it over to the U.S. Attorney's Office for additional charges. We didn't go through a whole rearrest. So the bill makes perfect sense. I'm just wondering, why do we go through all that? If the person's already in custody, they've already been convicted, and they commit another crime, isn't there somebody that can just refer the charges to the district attorney's office? You have to actually rearrest the person?
There has to be an initiator of that
Right.
situation. And we're talking about mostly rural jails. We're not talking about federal facilities.
Right, I know.
Where they have those folks. So a lot of that representative is initiating the paperwork to move the process forward. Under current law, they have no powers to do that. They would have to call someone in that had the law enforcement certification to effectuate that arrest and move the paperwork forward, even though the person is incarcerated at that time.
So this is really just to give them the ability to do the paperwork.
Correct.
Not literally go and
Right.
rearrest. Okay,
Right.
thank you.
Okay. All right. Any further, Will?
No, at the appropriate time.
Okay. At this time, we'll recognize Representative Lott.
I'd like to make a motion to pass.
Okay, motion made to do pass House Bill 996, working off LC 394093. All those in favor, please say aye.
Aye.
All those opposed, like sign. Motion carries unanimous. On to rules.
Thank y'all very much.
Representative, maybe you'll have better luck getting this bill out than you did the
I don't even
424.
want to go there today, sir.
You know my feelings on that. Bless your heart.
May I be excused?
Yes, sir. Go ahead. All right. Got one more bill. And I don't know that we necessarily move this bill today, but we do want to hear from the author of the bill, our friend from the coast.
I just made a nick of time, didn't
Yes, sir. If you want to go to the table,
I? I had two at the same time. I'm gonna do that, but I'm gonna hash something out first. Will you,
yeah,
spread these out on
we'll
either
be
side?
glad to help you there.
Y'all asked me a question last week, and I'm gonna give you that. Oh, wait a second. Apologize, Chairman, I just presented a bill in higher ed. It was very important to me.
Thank you. Thank you.
All right, Mr. Chairman.
Go right ahead.
All right, Mr. Chairman, I appreciate the opportunity to be here again, and apologize. I'm just catching my breath from running from one meeting to the other. As you know, a lot of these are on top of one another. This body heard this meeting the other day, so I think you understand generally what we're trying to do, but I will, for anybody that wasn't here, I'm going to try to start at 30,000 feet and explain the conundrum. So currently, as you'll see on, let me skip over, we'll come back to Section 2. If you look at Section 3, currently in state law, you'll see all the current language. So the current laws, the statutes on the books in Georgia today require that sheriffs report non-citizens, you'll see the actual language there, confined for any period in their jails to ICE. They do that through the LESC, that is the Law Enforcement Support Center of the United States Department of Homeland Security. Okay? We're doing this all across the nation. It is a requirement in Georgia statute that they do so. What we have today, the problem is that when that law was passed, no one contemplated the notion that sheriffs, obviously, whose duty is to follow the law, would actually ignore, and in many cases, we have proof, in many cases, intentionally violate the law. But that is absolutely what is happening in this state. There are sheriffs who intentionally, and I gave you some examples of that, some language straight from the mouths of sheriffs, who are intentionally ignoring that law. So the question is this: if you have a statute on the books that requires sheriffs to follow this particular law, if indeed that is good policy, as has been passed by this body, and not only this body, but the other body, and signed by the governor back in 2006, if that is good policy, then should we compel sheriffs to fulfill their duty to the people they represent or not? So that is what we're trying to do here, Mr. Chairman. So that's the 30,000-foot view, and now I'll just go through a little more detail. Section 2, very simply, and I don't have, Mr. Chairman, 1 second. Ben.
You need a pen?
No, I need to speak to Ben. If he said, Ben, will you get Andrew to bring us a copy of all of the
Highlighted?
the aggregate number of ICE detainers in correctional institutions. I want a copy for everybody, Ben. Andrew can bring them to you. They're in my folder. So currently, here's the way it is. This bill requires a very simple, less than a page summary of how many ICE detainers. Now remember, the ICE detainers in our Georgia correctional system are not the total number of illegal immigrants in our correctional system. They are a subset. Because remember, you have a situation today where the Biden administration has dramatically reduced the number of ICE detainers they're placing on individuals in the community. Okay, that's a fact. You can Google it, look it up, do whatever you want to do. But there are currently 1,579 ICE detainers in Georgia, in the Georgia prison system, the state prison system. That does not include jails, which we're speaking about in Section 2. Only in the Georgia system. They are, as you heard me mention before, for a multitude, I may have them here, he'll get it, a multitude of violent crime. There are 179, I think, is the number of murders, 200 and some odd child molestation, kidnapping, rape, the list goes on. So what this measure does in Section 2, Mr. Chairman, is require that aggregate summary, nobody's names, nothing. Just the aggregate number of ICE detainers for those crimes. And it requires that to be posted on the Department of Corrections website. That's called transparency and public safety for the people, Mr. Chairman. That is what Section 2 does. Section 3 goes back to where I began earlier. The real conundrum with this bill, which is now 1105, the real conundrum here as it relates to sheriffs. And so what this bill does, after you read all of the current statute, already on the books, because all we're doing here is compelling people to do what the law already is. What we do is to describe that process. Now that process described in here, the procedural, most of what you're looking at is procedural. It's about how they do this and how they report on it. All of that, to be very clear, in this bill was cut and pasted from the current Sheriff's Association policy that they train on for doing this, because the Sheriff's Association acknowledges this is the duty of all sheriffs. And Mr. Norris, who I've worked with, has been phenomenally helpful to me from day one. He understands. Whether he agrees with the bill or not is up to him. But he certainly understands the conundrum I'm trying to address. He understands the public safety reason I'm trying to deal with this. So they currently train their sheriffs and tell their sheriffs, this is your duty, this is state law, and here's the process they train them on. I took that language and I stuck it in the bill. They created, when the bill was passed in 2006, the Sheriff's Association was tasked with creating the procedure. This is their procedure, Mr. Chairman. It's not my procedure. It's the Sheriff's Association procedure. All right. You'll see that continues all the way on down the line there, Mr. Chairman. And I'm glad to answer any questions, but let me just get to the meat of the bill. Y'all have had this and have had plenty of time to read it, and I can answer any questions as needed to the best of my ability. But on line 138 through 140, you see the meat of the bill, where you have sheriffs who refuse and who indeed in this state campaign on, run for office on, a platform that they will not work with ICE. Interestingly enough, that's bragging you're not going to follow the law while running for the sheriff, for the office of sheriff. It shall be unlawful for any jailer to violate any provision of this code section. Any person found guilty of violating this code section shall be punished for a misdemeanor of a high and aggravated nature. That's the meat of this bill, Mr. Chairman. Section 4 is about reporting. The reporting section, again, that was placed in there to know that they're actually doing it. We have to know that they report it. So we would get regular reports. And I know the Sheriff's Association has mentioned to me and very helpful advice on many occasions on this. Their concerns about the process for reporting. I'm glad to hear from them and help them in any way. But what we want to ensure is that if the sheriffs have to follow a law, we know they aren't, we know many of them aren't, and we're going to require them to do it, then we have to have a way to, We have to have a way to verify that, correct? That's what Section 4 is. So, Mr. Chairman, that's what the bill does. That's what it's all about. It's about just trying to ensure, we tell people in Georgia, we don't have sanctuary jurisdictions. That's not true. If you don't have sanctuary jurisdictions, you would have we're talking about individuals. We're talking about a public safety framework. We're not talking about somebody just working somewhere. We're talking about somebody in one of our jails. Just like those I mentioned in our correctional system, those are individuals that have illegally broken into our country and then have committed a crime against Georgians or against society. This is a different conversation. It is completely a public safety conversation, which is why it's before this committee, Mr. Chairman.
Before we jump off too much, I know you said we had 1,579
That's correct,
individuals in the Department of Corrections custody that are on ICE, an ICE detainer. Do you have any idea what the total number of illegal immigrants, illegal aliens, people who are here illegally in this state, how many that number is?
No, sir. I don't know the answer to that. Maybe some others here that do. I know concretely from data I've gotten from the feds, we have more than the border state of Arizona. And I've spoken to, I've had the ability to work with a gentleman by the name of Ferry who worked with ICE under the former administration and was the chief of staff there. And I've learned a lot from some of these individuals. And what I've learned is that we have a real problem here in this state. And again, my focus has always been the same, Mr. Chairman. That's a broader issue. My issue is that which is related to public safety. When it comes to the criminal element of that is what I'm trying to address here, Mr. Chairman.
Any questions for the author of the bill? We have several that are signed up to speak here today.
Mr. Chairman, before you do that, could I mention one thing?
Yes.
With your permission. I've handed out, so that your members will know what I've handed out. I was asked by Representative Evans last time, I wanted to have an answer for her, if I was familiar with the letter that was before the body. I actually didn't have that letter at the time, but I have it now, and so to your question, I've discovered who they were. So Project South, and I gave you some, if you're interested in Project South, I have a much thorough copy for each of you of the data on that organization that opposes this measure. But you'll see before you, what I've sent you is just some of the articles they've authored recently, to include Israel as a top student of U.S. imperialism. The war on terror continues to target pro-Palestinian activists, cop cities in a militarized world. And of course, one that most interesting, the DHS and its legacy of terrorizing immigrants. So clearly that letter to Representative Evans' question is very simply from an organization that is opposed to any and all immigration, is obviously supports open borders, and is opposed to our federal authorities removing anyone from this country. That's the answer to the question, Representative. Thank you, Mr. Chairman.
Okay. Any questions for the author of the bill before we? Mr. Norris, you have anything you want to say? Yes, sir. If you'll go to the podium, please. Our friend Terry Norris with the Sheriff's Association.
Thank you, Mr. Chairman and members of the committee. Deja vu all over again. So thank you, Representative Petrie. So a couple of things. We do not know how many sheriffs are not reporting to ICE, Homeland Security. There's been some inquiries by others who may have information. It is the policy, of course, of the Georgia Sheriff's Association to to train the sheriffs on compliance with law. And as such, we did, and the representative placed some of our training variables into the bill. So to make it perfectly clear, we don't know how many sheriffs. We presume there are some because some have said they wouldn't. Number one. Number two, we have trained on this issue. We will continue to train on the issue. But there's a piece to this that we don't understand, and that is how this check actually occurs. The representative described in general how it does occur. It is, and we're trying to find this out now. We are trying to reach out to GCIC to see that when we do a name check on Terry Norris, how that check runs toward the law enforcement support group to identify whether I'm here legally. We're a little fuzzy on that, so we are, as I said, looking into that. So hopefully before a subsequent conversation, assuming there is one, we'll be able to describe that process more. There's a real important fundamental, though, to all this. If U.S. Department of Homeland Security and ICE has never had contact with Terry Norris, they're not going to know whether I'm illegal or not, because I'm in the country. So far fewer people that they're running the criminal history record check on are getting any kind of response from ICE, DHS. That was told to me by one of the sheriffs this week. So when there is a return of yes, we know Terry is here illegally, and what's he charged with, that kind of conversation, then sometimes a detainer is placed on that person. If it's not a serious felony offense, Terry Norris is going to get out of jail just like any citizen of the United States is, if there's a bond, 24, 48 hours. So there's a lot of fuzz out there for us in understanding this whole process. In terms of the bill, we said it the other day, and we'll repeat it. If a sheriff is not complying with whatever this process is and is intentionally not doing it, certainly they should be doing it, and certainly there should be a sanction. Our recommendation on the sanction was to create a situation where it's a violation of oath of office. If there is a violation of oath of office, presently in our law, the governor can appoint 2 sheriffs and the attorney general to look at the situation, misfeasance, malfeasance, violation of the law. So there's something already in the law that exists, and our recommendation would be, rather than criminalizing it through a misdemeanor of higher aggravated nature, to use that code section. And finally, as important to us at the Sheriff's Association, I said to you all the other day, we've stood up a more robust jail reporting system. We want to know who's in jails, not only illegals, but how many are on probation, parole, whatever it is, because we want to give the General Assembly a more accurate picture of what criminal justice reform and other state policies have done for the local jail population. A lot of people in jail now are there. In the past, they may have been in prison. They're on probation. Vast majority of people in jail now are on probation. And these are people that should be in the state prison system, but no, they're not. They're in the county jail. So what does that mean? You and I as local property taxpayers are paying for all sorts of drugs, psychotropics, and everything else. So our jail, not to digress, but our jail population is an important thing for you all to know about. This would be a very important addition to that jail population report. So those 2 things are what we have in mind. Again, we want to better understand this whole process of going through GCIC to Homeland Security and ICE, and if we've got sheriffs not doing it, we'll be the first ones to try to help them understand the need to do it.
Fair enough. Any questions for Terry? Representative Lott.
Mr. Norris, thank you for being here. Thank you for all of that. So you've kind of got me thinking about a few things, but is the other reporting required do we know, you were talking about transparency, do we know our jail population even beyond this concept?
By individual jail, we do. And we started this new jail report. As I mentioned the other day, the State Department of Community Affairs did a very simple jail report up until last year or earlier in the previous year. So we took it upon ourselves to do the jail report. We work for the sheriffs. We have the best line of communication with the sheriffs of anybody in this state. So we've often, in my 30-year career, we've often had to go to a sheriff and say, Sheriff, you do realize you have to do this. Or, Sheriff, you've got open records requests on this. Have you thought about replying to it? So we think that, I don't think we need legislation to do it, although it would help me get compliance with my jail report. We've got about half the sheriffs that have jails, 142 jails in Georgia, about 38,000 people in county jails. So about half of those, a little less than half, are reporting to us. And it is our constant challenge to get these more and more sheriffs with jails on board. The hang-up a lot of times is their jail management system and integrating their software system with what the data we're trying to collect.
So further in question, just in relating to what Representative Petrie is doing, is there any benefit or is it too complicated to add the additional reporting requirements? Maybe I know what the representative probably said. That's probably just complicating his bill, but but we have a lot of sort of loose ends in our jail, including how long our folks have been there.
Mm-hmm.
Some of that plays to the DAs that are sort of doing the similar thing as your sheriffs, which is not moving certain cases, that kind of thing. So does your agency have reporting on that, or again, it's just half of your sheriffs, your jails that are reporting?
Two answers. Half are reporting to us now. We're continuing our, for lack of a better term, marketing to sheriffs to explain how important this is for them to report to us so that we can tell you, so that we don't see something in a bill that says, Sheriff, you got to report this to the Department of Audits, which to us, no disrespect, is totally unacceptable. You all are going to be setting policy. We would disagree with that policy. So we want our jail report to be the most robust possible. And as far as what goes into the jail report concerning this matter, we certainly would want to not necessarily go line to line, even though we are training this way. For instance, there's a part in here that says that you got to report on those that are in your jail illegal. Well, how's the sheriff going to do that? How do you make that determination? Who do you go to? That's not something that the sheriff's able to do. If it is confirmed that this person is illegal and we're following the law to determine whether ICE says they're illegal, then yes, we want to report that. Do we want to report the number of detainers? Of course. We can report all of that. But a few of these things in here that we actually train on is somewhat unreachable to most of these sheriffs.
Thank you.
Okay. Representative Evans.
Thank you, Mr. Chairman. Yeah, so I guess that's just the note I had, and it sounds like you just talked about it because you were making your points, and you said number 3 was how does the check work for law enforcement? How do you go through GCIC? And so you're saying a lot of it's unclear about how you'd be able to how the sheriffs would be able to comply with this law.
Well, what I'm saying is it all starts with an arrest.
Right.
And the arrest is not always done by the sheriff. The arrest is sometimes done by the Atlanta Police Department. It goes to Fulton County Jail, for instance. Mm-hmm. So when that person is arrested, that person is booked in jail. Fingerprint, photograph, basic information. Unless that person admits when they come in the door that I was not born in this country, we're not going to know. Especially if the next piece of that is that information is pushed along of this arrest to the Georgia Crime Information Center. But what it does after that, and the representative mentioned this, a law enforcement support group, that's the part that we're a little bit unclear about. Does that information come back to GCIC and they know that Terry Norris was not born in the country and ICE has been told about it, or is it something that the sheriff actually pushes themselves? And I don't know the answer to that. I thought I did the other day. I testified more clearly about this until I started talking to more sheriffs. But I really believe, y'all, that we will do this. We need to we need to have a better conversation with GCIC to get this explained to us. And Representative Petrie and I talked about this the other day, and I think he agrees with that. Do you not agree with the GCIC thought?
I agree. We certainly need to understand your concern.
Have I misstated? Because I mean, you seem to be more clear about some of this than I am.
Well, so, I want you to be thoroughly heard, Mr. Norris, but here's what, to the question, so what this does, so I can't imagine trying not to identify someone being placed into a jail, and what this does, the process is clearly outlined. You positively identify the individual, and it goes on to talk about a Form I-94, it talks about a passport, it talks about resident alien card. So individuals that are in the country even if they're non-citizens, are required to have identification. And all of those things are kind of described here. So there's a multitude of ways we can try to discover who someone is. It would seem to me that that's important, especially today. If you look at the news, if you look at polls, the number one concern on people's minds today, we've had 10 million people in the last 3 years enter the country illegally. Okay? So as a matter of public safety, we should know who's winding up in our jails for a multitude of crimes. And I have a hard time getting my head around that. Again, Mr. Norris has been most helpful to me, and I want every issue he has to be heard. But I have to also be honest with you and tell you this. This is a bill that's been in the books for 18 years. 18 years. And basically we're hearing that half the sheriffs are doing it. I have a hard time understanding that, Mr. Chairman. But I want every concern. My sheriffs support this. I represent 2 of them. They're all in. They tell me they do it right. And they tell me it's not a burden to do it right. But I've got a quote from a Georgia sheriff. I'm sure there's others. Quote, "What we will not be doing is notifying ICE of anybody's immigration status in the jail or any of our facilities." So we can debate minutia all day long, and I want to get the minutia right because it matters. But what we need to do is deal with an issue that I believe is very important to the public safety of this state, and I don't want anything to derail that. Glad to work the process out as long as we can ensure people are doing it and then they report it such that we know they're doing it. I'm happy, Mr. Chairman.
And we agree that everybody ought to be doing it.
Yes, sir.
Absolutely.
Yes, sir. Representative Evans, you have
I have one more question for Chairman Petrie. Do you think asylum seekers are illegal criminal aliens?
No, ma'am, I do not.
Okay.
But they also have identification. So we're not talking about asylums. We're not talking about anyone here on a visa or any kind of legal, a multitude of reasons. We're talking about, in other words, we're talking about anybody, including U.S. citizens. So if I'm in a jail, they're going to positively identify me, right? Shouldn't we be doing that with everything? Or do citizens only subjected to something that non-citizens aren't?
No.
Of course not. So what we're talking about is positively identifying everyone who goes into jail. So it doesn't matter who they are. I mean, this is so commonsensical, I can't fathom otherwise.
I want to throw this out here, if I could, to my friend, Chairman Petrie. You digress back to a point that Mr. Norris was trying to make. I think we're living in a fool's paradise to believe that everybody that comes across the border is going to have some type of form of identification.
Correct.
And so
Correct.
what are we going to do about those people that we don't have anything? We don't know who they are. We don't know where they came from. They don't have fingerprints. They don't have a history. They've just shown up on the doorstep of America, and they have been accused of committing a crime. So how are we going to ask our sheriffs to report those people?
Mr. Chairman, the bill only requires, the current statute only requires they report that to ICE.
They don't know
They
who
can
they are.
fingerprint them like they do everybody else and send it to ICE and go home. The measure, you got to remember, because it gets obfuscated sometimes, they don't have to do anything but send it electronically to the feds.
And if the feds
There's
don't come
pushing
back,
a button and saying, here's the guy, I can't find any identification. I've tried all these avenues, and by the way, if you're interested, look on 51 on down, the multitude of ways, whether they have a passport, if they don't have any of that, here's who I got. He's in for a crime of rape or whatever, and you've reported it to ICE. To Terry's point, they may not know anything about this individual, but they may.
right?
Okay? But they may. And if they don't, your obligation, your duty is to do nothing but report.
Very clear.
We're not asking them to do anything after reporting.
Very, very clear.
It's very simple.
Representative Cummings.
Thank you. I don't know if you were aware there was an article in the AJC that came out in 2019 about this, and there seems to be a cost. I know Gwinnett from 2009 to the time of the reporting in 2019, they had paid $15 million to comply with the program, and Bartow County tried to comply with the program for 13 months, and then they sent in something to ICE saying they couldn't participate because they had a staff shortage. So I'm just wondering if you knew about any of that, because not every sheriff's department is not complying just to be not complying. And if somebody has a staff shortage, and we know a lot of law enforcement agencies do have staff shortages now, and if the sheriff determines, I don't have a lot of immigrants, it's not worth it, and we don't have the time, the staff or the money, how is that going to be dealt with?
Yes, ma'am, I can speak to that. I think I don't know about the specific situation, but I know what you're talking about. You're talking about a program called 287G. 287G is completely unrelated to this discussion. So yes, formerly the sheriff of Gwinnett County and Cobb County worked with 287G. New leadership came in and did away with that. I would suggest it was a lot, look at the comment I just read to you. There's a lot more to that, the reasons for discontinuing that program than funding. However, to your good point and fair point about the cost to a system, they don't have to work with 287G. That is a completely separate issue. Remember, the current statute doesn't say you have to work with the 287G through the federal program. It says you have to report to ICE when non-citizens are in your jails. Nothing more. It is literally pushing a button, sending information to Law Enforcement Support Center of the United States, Department of Homeland Security, and you're done. So there is no fiscal issue here, but it's a very good point, because I think it's helpful to let everybody know we're not talking about 287G, which some systems work with, some don't. That is a completely different issue.
Representative Saines, you have a question, comment?
Thank you. And I initially marked to clarify that statement, because I assume the author is much more knowledgeable than I am, but has already cleared that. But I wanted to highlight, because I think it's important, even if there's a small cost, but not to that level, what we're saying here is that it is a public safety data point to ensure that we have a consistent information on monitoring those in our jail that may or may not stay there, may or may not be adjudicated in different capacities, who in our jail we have accurate understanding is here legally or not, because that has different public safety implications on finding them, having them in our GCI system, being able to find them for warrants, et cetera. Is that the summary of the public safety need?
I think so, Mr. Chairman, and to your point, we all know, unfortunately, that the level of recidivism in our criminal populations, all criminal populations, which are mostly our own citizens, we know the level of recidivism. We don't know who this person is. How do we know they didn't? Perhaps they were just they were just in a jail in an adjacent state for some other crime. This is about public safety, and yes, I think people. I think people recognize that.
Just
I'm
one.
hopeful I get Ben's. Do you have my papers? Yeah.
One small follow-up, because I think is important to make clear. There are some questions about asylum seekers being confused to this, which is clearly not associated. But this is a pro-legal immigration bill. Is it not true that those that are left vulnerable are by those who would come out of jail, be unmonitored, are oftentimes those in our minority communities? So this is a pro-safety bill, a pro-legal immigrant bill, and is purely just ensuring that our state has an accurate depiction of this population.
I would say, sir, Chairman, this is a pro everybody in Georgia bill. If you're interested in public safety, and yes, to your point, if you have people not in the country, their victims tend to oftentimes be in that same community. This is about simple public safety. And to your question, I finally have your report. Does everybody have a copy of this? Yes. Right. So, listen, is it important? I don't know. There's at least 241 children who've been molested in this state, according to the ICE detainers, by people illegally in this country. Do their families care? I suspect they do. What about the 182 murderers? That's at least 182 people, Georgians, murdered.
Those are people that have been convicted of murder.
That's convicted.
That are inside our
this
prison
is just
system.
and this is just in a jail. Let's just make sure we know who is in this country if they're committing crimes. This is very simple, Mr. Chairman.
Now we're going to hear from Mr. Norris, you have one more comment. We've got a
One
few
more quick
people.
comment, for clarity's purposes, we fingerprint and ID everybody that comes to a jail. For a lot of reasons, mainly liability, who's in there. So I didn't want the committee to think that we did not. We fingerprint them, it goes to the Georgia Crime Information Center, to the National Crime Information Center, to the U.S. Department of Homeland Security, ICE, those places. But if we don't get anything back, a warrant or a warrant on someone, they can get out of jail like anybody else, and they should get out because nobody wants them, other than this particular offense, which they call, for that purpose, clarity.
Okay. We've got several people that want to speak, and what I would say to you is we're losing our room here, and we've heard a lot of comments about this, and I'm going to give part of the legislative process is to give you a voice over here, and we want you to be able to speak. We're going to give you 3 minutes. If you want to all line up behind the podium there, we're going to start off with Jennifer Lee. Jennifer Lee. Next behind her will be Jennifer Lopez. If you'll be clear and concise and to the point, please.
All right, thank you, Mr. Chairman. My name is Jennifer Lee, and I'm the Policy Director at Asian Americans Advancing Justice Atlanta. We're a nonprofit legal organization dedicated to protecting the rights of Asian American and other immigrant communities in Georgia. One of the things my organization does is provide immigration legal services to a wide variety of clients. So our attorneys do things like assist individuals through the U.S. citizen application process, and sometimes help them obtain lawful status. We're also involved with policy advocacy at the federal level to address certain flaws in immigration law that have harmed some of our clients. And so I just want to lift up a couple of examples because I think it's important for everyone to understand that immigration law is not black and white. It's very complicated, and there are a couple examples that we've seen with our clients I'd like to lift up. And first is the case of international adoptees. So hundreds of thousands of children have been internationally adopted by U.S. citizens since the 1940s. And prior to the passage of the Child Citizenship Act in the year 2000, that's a federal law, adopted children were not automatically granted U.S. citizenship. Many adoptees and their families incorrectly believed that their children did become citizens upon adoptions. And there was a attempt to update that flaw with the Child Citizenship Act, which did update that policy. So fortunately, that is federal law now. But it left out a lot of adoptees that were born before 1983 who do not receive those same protections. So many of those older adoptees that we see now in our communities are in legal limbo and have been vulnerable to deportation. Another related flaw related to that same Child Citizenship Act, there are many individuals who were children when they moved to the U.S. to live with their fathers, and their fathers naturalized to U.S. citizenship. Today, these children would become U.S. citizens because they had U.S. citizen fathers.
60 seconds.
Thank you. But in the past, this did not apply to many parents who did not have legal marriages that were recognized in the U.S. And again, that policy change was not made retroactive. We've represented clients who've lived in the U.S. for nearly all their lives. They believe themselves to be U.S. citizens and then were deported because of these flaws in immigration policy. So these are just a couple examples. We believe that mandating local officials to do this type of blanket immigration enforcement just incorrectly targets limited policing resources, and we're afraid that it will mistakenly harm families and communities in our state. And so thank you for your consideration and understanding that some of these cases are just very complicated and people can get caught up in these aggressive policies. Thank you.
You know, again, if you don't break the law, you won't get caught up in this piece of legislation. Next, we have Jennifer Lopez.
Good afternoon, Mr. Chairman and members of the committee. My name is Jennifer Lopez, and I'm with the Georgia Latino Alliance for Human Rights, also known as GLAR. GLAR is a nonprofit community grassroots organization that educates, organizes, and empowers the Latinx community across Georgia to defend and advance their civil and human rights. So we are here today to oppose HB 1105. And the majority of this language in the legislation echoes Secure Communities, which is a former DHS program that was discontinued in 2017. The program identified undocumented individuals who had been arrested, booked, even for violations as minor as a traffic stop. So just like HB 1105, the Secure Communities program was flawed and did not target convicted criminals who were deemed violent and dangerous. And in 2011, 26% of those deported through Secure Communities were only guilty of being undocumented and had no previous criminal charges. Because it targeted people at the time of arrest and not conviction, Secure Communities detained individuals who were never charged with a state crime, as well as those who were wrongfully arrested. Additionally, HB 1105 will cause the unlawful detention of U.S. citizens. The use of the phrase suspected foreign national raises some concerns of increased racial profiling in arrest proceedings. For example, in 2008, Gilmar Ramos Gomez, who served as a U.S. Marine, was issued an ICE detainer, even after his proof of citizenship was available. He was in custody for almost a month, so this bill would put officers and sheriffs in a difficult situation, opening up cases of civil and human rights violations. GLAR has sent numerous letters throughout the years to sheriff's offices in order to help them understand detainer policies and avoid costly liability. We urge you to take everything that was stated into consideration and vote no to HB 1105. Thank you.
Thank you very much for coming. We got Kyle Gomez Lineweber. Lineweber.
Yes, sir.
Okay.
Thank
Go
you.
ahead.
Thank you, Mr. Chairman and members of the Public Safety and Homeland Security Committee. My name is Kyle Gomez Lineweber. I'm the Director of Public Policy for the Galileo Impact Fund. Our organization advocates for and uplifts the voices of Latinos throughout our great state. To that end, I stand before you today to express our serious concerns with this bill. Particularly, we have concerns around the language around mandating jailers to identify inmates as suspected foreign nationals. It's not only vague on the actual process, but it establishes, but it would likely lead to racial profiling. The bill will not just lead to disproportionate disruption of lives for low-level offenses or even charges that are ultimately cleared, but given the aforementioned language and the reality of an immigration system that I think everyone here agrees is broken, it is likely that our own citizens, particularly our Latino citizens and legal residents, will be unnecessarily put at risk. We've seen this play out with programs like 287G and instances where citizens and legal residents who happen to be Latino were deported. If passed, this legislation will drive a wedge between local public safety officials and the communities they serve. This will be especially true in divisive and communities where trust of law enforcement is already tenuous. This creates an additional burden and responsibility for local jurisdictions at a time when jails are understaffed, struggling with overcrowding and basic upkeep. Programs like this have been tried before with no tangible success in making our communities safe. According to GBPI, between 2008 and 2018, local governments spent $88 million to participate in 287G. Today, just 6 of Georgia's 159 counties participate in 287G. And we understand that this is not 287G, but there are similarities in process, and we believe in impact.
30 seconds.
Thank you. These types of unfunded mandates are not the kind of support our communities need. Overall, HB 1105, if it becomes law, will almost immediately get tied up in the courts at the Georgia taxpayers' expense. And even if this bill were to be enforced, the result would be a costly, discriminatory, and disruptive program that would hurt Georgia communities, businesses, and families.
All right, thank you for your time. Mr. Sereno? Ms. Sereno?
Is it Rosario?
One more time.
Rosario Palacios?
Let's see. Sure.
Okay.
Go ahead.
Thank you.
You got 3 minutes.
Yes, sir. Thank you, Mr. Chair, and thank you to the committee. My name is Rosario Palacios, and I'm a mother of 4, a caregiver to my spouse and my mother. I'm also the executive director to Georgia Familias Unidas. I dedicate a lot of my time volunteering in my community, promoting higher education and tech skills in the professional development of the community that I serve. I'm also a former poultry plant worker, which is why Georgia Familias Unidas was started, to aid a lot of the folks in Gainesville who have worked in poultry or their parents worked in poultry. And so I come today as someone who shares many lived experiences with the community that I help advocate for when it comes to some of the non-intended implications of laws like this. I have reviewed the language in this legislation. I've not only lived these experiences, I've served as a policy analyst for nonprofit organizations for 8 years. Section 3 of this legislation requires more processes and changes what federal law we're using as the standard for what is deemed as someone who should be targeted or should be detained and held for further questioning and further profiling. So this law has gaps that I worry about for our survivors of domestic violence. And I bring this up as a survivor myself. Growing up in Gainesville undocumented, I saw my U.S. citizen father leverage his privilege of status against the status of his own children and my mother, who survived many, many years in physical abuse. I also can say this as a survivor of domestic violence myself, that when I was a legal permanent resident, before I became naturalized, I thought twice about calling law enforcement, because if there was any kind of scratch on the abuser from me defending myself, then I knew what would happen. I knew that law enforcement could take both of us into custody, and then that my immigration status would be in question.
60 seconds.
Thank you. I have lived these things firsthand. I know what systems like 287G looks like, and I've reviewed the language in Section 3. I know that Section 3 DB doesn't even allow for any kind of paperwork that I have as a naturalized citizen. And I think of people like my sister, Maria Esther, who came into the border, was allowed into by immigration officials as an asylum seeker, and I think like I have lived, like my mother has lived before. So I ask that this committee look through Section 3 much, much more. Honestly, I oppose the entire bill, but Section 3 doesn't just have implications for sheriffs, it also has implications for people who are detained and not convicted of any crimes. And as a domestic violence survivor and as one who serves the community of many mothers struggling with this issue, I ask that you please consider their cases and vote no on this legislation.
Thank you very much. We appreciate you being
Thank
here
you.
with us today. Giovanni Cerrito. And then after Giovanni, we'll have Gigi Pedrazira. Okay, go ahead. You have 3 minutes, please.
Good afternoon, Mr. Chairman and members of the committee. My name is Giovanni Serrano. I am a community organizer with the Georgia Latino Alliance for Human Rights, GLAR. And today we are here to post HB 1105. There is already a federal program that the Department of Homeland Security purpose to focus its jail status check programs. That is known as the Criminal Apprehension Program, CAP, on immigrants with serial criminal backgrounds. Under this program, individuals in jails or prisons might be identified by CAP when they have only pending charges and will be included as CAP removals even if they have never been committed of a crime. According to the Department of Homeland Security statistics, a large percentage of immigrants apprehended under CAP are not criminals at all. For instance, in October 2009, the DHS report found that 50% of immigrants identified to the CAP in fiscal year 2009 had no criminal convictions at all. Also, in a study conducted by the GBPI, they found out that during 2003 to 2020, most of the undocumented people who were apprehended in Georgia committed low-level or non-violent infractions. The approach to enforcement on HB 1105 focuses broadly on the apprehension of all undocumented immigrants, not just those with a criminal record. And prioritizing immigration enforcement over broader public safety concerns results in significant compounding harm to the immigrant community. We saw an increase in these predatory practices during 2019 to 2020, where political parties do not have any leverage for their political platforms and nothing else to elude their support than increasing anti-immigrant sentiment to win political campaigns. Moreover, HB 1105 puts an extra burden on jails who are already struggling with retention of officers and are being by punished. Then by the punishment in this bill, it makes this job even less appealing to potentially have more people apply and have more people running the jails, which we know is a major issue all across the entire state of Georgia. In addition, in this year, where our legislative body is focusing on protecting our youth, we cannot take for granted that in our state, in the state of Georgia, Latinx teens with a family member who is detained or being deported have experienced an increased suicidal identification, alcohol consumption, and aggressive behavior. This is why one of the reasons why we urge you to vote no on HB 1105, because it has a major cons on our youth who are experiencing many cases and with lack of mental health services in the state of Georgia, is causing many of them to potentially be detained and sent to county jails too as well. So thank you so much.
Thank you for being with us today. Gigi.
Good afternoon. My name is Gigi Pedraza. I'm the Executive Director of the Latino Community Fund in Georgia. We are a nonprofit organization. Yes.
Okay, go ahead.
Nonprofit organization working to advance people's democracy, protecting and building community, and expanding economic opportunity. Today, I am here to bring some examples of the imperfect records that exist at the Immigration and Customs Enforcement's Office, just as Director Norris mentioned. Between 2002 and 2017, there were over 2,800 American citizens I had wrongly identified as eligible for deportation. Today, I'll share 3 of them that actually pursue legal action, one of them in Georgia. Mark Little, in 2018, was a citizen that was deported to Mexico because of the records that ICE provided. He was held for 6 weeks with no legal assistance and deported. From Mexico, he was deported to Honduras because he was not a Mexican national. In Honduras, he was imprisoned and jailed for weeks. From there, he was deported to Guatemala, where he was eventually able to reach the U.S. Embassy. The U.S. Embassy talked to his brother, who served in the military and was able to get a passport, a U.S. passport. He was able to fly back to Georgia, where for hours he was detained. There's a legal case in Georgia because of this case. That was 2018. There's a similar case, Eduardo Caraballo in 2011, Sergio Carrillo in 2017. So again, these are just 3 cases that I bring to your attention. We believe that the language is imprecise in this bill. We believe the process is extremely difficult to be implemented, and that it places an undue burden on local jurisdictions, like our colleagues have shared. Additionally, this creates additional expenses to taxpayers in Georgia. Thank you for your time. We are opposed to the bill.
Thank you. We have next David Schaefer. It's David Schaefer.
Thank you, Mr. Chair. My name is David Schaefer. I'm the Vice President of Research and Policy of the Georgia Budget and Policy Institute. Our aim is to advance lasting solutions that expand economic opportunity for all Georgians. We rise in opposition to this bill. In addition to agreeing with the sentiments provided by others in this room, I do want to highlight that we are unclear how much this thing would cost. And we think that there could be fairly substantial fiscal implications. A colleague from Galeo has already mentioned one figure, around $88 million, just to give one as to the cost of detainer enforcement from 2008 to 2017 to Georgia city and county governments. Would also say that many times the feds are not covering these costs, and federal grants are really only covering about 3 to 10% of the cost of reimbursements in the enforcement of detainers. So without a fiscal note on this bill, without really a sense of what the cost is, it's very difficult to make, I think, a wise decision on its implementation. In addition, I'd like to say, after working in this area for 20 years, including as an immigration attorney, there are a lot of unintended consequences. People do get caught up in systems. If there is not clarity around what things cost, if it's not clear what procedures should be implemented when, there's always somebody that was unintentionally caught up in that. It complicates their lives. It often happens at greater scale than we ever imagine. And I've seen that both as a paralegal working in the Georgia Department of Corrections and working on the immigration side, both in sort of Superior Court, but also in the local immigration courts here in Atlanta. So I wanted to raise these issues, and we rise in opposition to the bill, but we do agree with the sentiments previously stated. Thank you so much for your time.
Thank you. Megan Gordon will be next.
Hi, Mr. Chairman, members of the committee. I'm going to go real fast because I'm doing the same committee shuffle y'all are doing today.
Bless your heart. Go ahead. Go ahead. Thank you.
I know y'all can relate. My name is Megan Gordon. I'm the policy manager at the Georgia chapter of the Council on American Islamic Relations, and I just want to point out a technical problem with this bill. Y'all have heard asylum mentioned a couple times today, and I want to point out why that is. If y'all would join me on line 47, if you were so inclined, that's where the legislation sets out the standard for which law enforcement will be looking when they are deciding whether they need to notify ICE about someone. And that says they're looking for lawful admission and current lawful status of the foreign national. That is where we have a problem, a legal problem, because there are multiple types of immigration status where someone could enter the country illegally, but then gain lawful status. DACA is a pretty commonly known one. People come in as undocumented children and then gain status. Asylum is one, because in asylum cases, someone crosses the border illegally and then presents themselves to law enforcement and says, "Hi, please help me. It's not safe for me in my country. Please put me through the legal proceedings to give me status." And so by putting that in, we're essentially raising the bar higher than federal immigration law. And we'll be notifying ICE of people who are actually legally entitled to be here. And now I won't pretend to have insight into the back end of law enforcement. I don't know what ICE is going to do about that. We are compelling law enforcement to call them. I don't know if ICE is going to say, "Hey, friend, thanks but no thanks, have a good day," or if they're going to actually show up and put into deportation proceedings people who don't need to be in deportation proceedings, because as Gigi said, mistakes happen. There are people who have been deported who shouldn't have been, because if we all agree on one thing, it's that our immigration law is a hot mess and it's very difficult to understand.
Okay. Thank you for being with us today.
That's all I had for y'all. Thank you.
Okay. Mr. D.A. King, I'm going to give you 3 minutes. You feel free to just take one if you'd like to.
Thank you, Mr. Chairman. My name is D.A. King. I am president of the Dustin Inman Society. The Dustin Inman Society is named after a young man from Woodstock, Georgia, who will always be 16 years old, because there's a lot of people who do not want us to enforce our immigration laws, pretty much the most liberal immigration laws on this planet. It's difficult for me to sit back there. I was here on this campus and helped create both of these laws and and helped modify them in various years. What you are hearing from people who do not want to punish or even report illegal aliens in this country is pretty standard boilerplate stuff from every hearing that's ever happened any place near this Capitol on illegal immigration, or the state taking an effort to do what the federal government refuses to do. I'm not completely clear that everybody understands that what this bill does is it inserts penalties into existing law. That's right. As Representative Petrie mentioned, the 42414 is from 2006. That's 18 years ago. The other one is 368023. It's from 2010. I put that at 14 years ago. We're not trying to relitigate that law, I hope. I hope we are considering whether or not we are actually going to make a move in this state to compel the Sheriff's Association, to compel the sheriffs that they represent to actually enforce, comply with the law that's on the books, as they are sworn to do. I'm trying not to talk too fast, but I've seen numbers that, from an internal poll, when I spoke with the Sheriff's Association over the course of at least 5 years, I've seen numbers that show 86 sheriff's offices are in compliance with this. Maybe that number has gone up since last year when I saw it. But as I mentioned before, after 18 years, that doesn't seem like a real good effort at compliance, and I hope none of us ever try to go that long without obeying a law. There's a mention of we can punish the sheriffs who are not in compliance
60 seconds.
By charging them with a violation of oath of office and then forming a panel for the governor or by the governor, and then check it out from there. Again, I respectfully observe that the law's been on the books for 18 years, pretty much everybody in the Sheriff's Association knows that it's not enforced, but there has been no panel. I have no reason to believe there would be if you don't put penalties in this law, in these two laws. If we don't pass this bill out, I'm pretty sure I know what will happen. I've been doing this for 20 years. I don't know if my 3 minutes are up. I've got a lot more to say, but I'm glad to go away.
Do you think?
We appreciate you.
Thank you, Mr.
appreciate
Chairman.
you.
Are there
Thank
any
you.
questions?
I think we got one question, but I don't know who that's. Representative Sains.
It's not targeted to you. I just wanted to make sure to clarify, just based on the testimony we received. I'm not sure the constituency that all the groups represent, but I want to make sure everyone's clear that according to the Bureau of Labor Statistics, Hispanic citizens and legal residents are 3 times more likely to be victims of rape, robbery, or assault. And the way I see it, this bill directly impacts and reduces that statistic. So I don't know the constituents that some may claim to represent, but that's the one I'm concerned with. Thank you.
Thank you. I'm going to give the last word to the chairman.
Thank you, Mr. Chairman. I'm going to say something I've got to say. So to the groups that spoke, so I almost want to ask those that spoke today if they've read the bill, because quite frankly, even the Georgia Budget and Policy Institute, I don't know that the gentleman's read the bill. It makes it clear in here. This has nothing to do with detaining anyone. Line 116, inmates shall held no longer than 48 hours. Line 108, an inmate identified as an illegal alien shall not be detained on the basis of being an illegal alien. My friends, this is all an intention to obfuscate the facts. And here are the facts. This bill requires one simple act: reporting. Not detaining. You had multiple conversations about detaining. Nothing in this bill requires that. Nothing in this bill has to do with any way. Somebody spoke to apprehension of illegal immigrants. This is not, these individuals are already in jail. This is not about apprehension. It's not about detaining. This is about simply reporting, Mr. Chairman. And there's one other thing I want to say. The issues that the individuals that are speaking against this measure have is with the current statute. The current statute, if you look at Section 3, that whole beginning there is current law. Doing this is already law. All I've done is put a penalty for those who don't. So their problem is really with the bill that is already, the law that is already on the books. It isn't with what I'm trying to do. What I'm trying to do is take the process that is currently utilized, put it in the law, and require that it be done. Mr. Chairman, that's what we're trying to do here. In this law, as I said last time, either put a penalty in there to require it be done and reporting that requires it be done, or move to eliminate it altogether. Somebody offer a bill to eliminate the measure altogether. There's a lot of folks in this room would just rather you not do that. But what would the people of Georgia want? That's what we've got to deal with here as policymakers.
To the members
Mr. Chairman, that's all I have to say.
To the members of the committee, thank you for hanging in there with us. I hope to see some advancement of this bill next week. I'd like to ask the author of the bill and my friend if he would continue to work with the Sheriff's Association. I do think it's imperative that we have some buy-in from them and have some kind of comfort level as we move this bill forward. I think this is a good piece of legislation that will benefit public safety and the citizens of Georgia. There being no further committee business, we now stand adjourned.
Thank you, Chairman.